Hello and welcome to this short interview about the recent case of Clitheroe and Bond and some practical considerations arising out of it. If it's morning and you haven't got yourself a quick cup of coffee, then please do so. My name is Kate Selway and I have with me Ed Hicks. We're both Chancery barristers at Radcliffe Chambers. More importantly, Ed, along with another of our colleagues, Tom Dumont, acted for the respondent in this important recent appeal decided by Mrs Justice Falk earlier this month. So I'm going to let Ed in a moment do most of the talking, but to give you a very quick summary, this case is all about testamentary capacity and specifically the extent to which delusional beliefs can impair testamentary capacity. And I'll just tell you ever so briefly about the parties to the litigation. They were John and Sue, a brother and sister, and their mother, Jean Clitheroe, had been profoundly affected by the death of her eldest daughter, Debs, John and Sue's sibling, in 2009. And thereafter, she'd effectively taken to her bed until her own death a number of years later in 2017. And after the death of Debs, Jean had made 2 wills, the terms of which reflected a growing estrangement with Sue. And Sue claimed that her mother was suffering from a complex grief reaction and a continuing affective disorder that was manifested by depression and, more importantly in this case, insane delusions regarding Sue. So, Ed, let's turn to the questions. The burning question at the forefront of my mind is whether you think this is the end of the debate on the test to be applied in testamentary capacity cases. So, does Banks and Goodfellow remain good law now, or has the test set out in the Mental Capacity Act 2005 assumed greater importance after this case?
Well, the argument was run on appeal, not before the Master at first instance, that the proper test was the Mental Capacity Act. That was the appellant's position, and that argument failed. But what Mrs Justice Falk actually decided was that she wasn't going to allow that argument to be run essentially as a case management decision because it had not been run below. Indeed, it had been conceded below that Banks and Goodfellow was the correct test, and that the burden of proof lay with the person propounding the will, which was John. So, having not run it and having had all the evidence, cross-examination in particular, and the cross-examination was focused in some respects on the burden of proof, it would be moving the goalposts afterwards to allow the argument to be run. So, strictly speaking, what the judge actually went on to find on which test applied is obiter. But she did give a detailed judgment. She had a great deal of submissions on this point, and gave a detailed judgment, rejecting the Mental Capacity Act arguments. So I think to answer your question, this is a pretty serious nail in the coffin of the argument that the Mental Capacity Act applies, but it's not a stake through the heart if this matter or in a similar matter ever goes to a higher court, so to the Court of Appeal or Supreme Court, then we might get a definitive answer. But for now, what we have is a growing body of High Court case law with Walker and Badmin, and then you have James and James, and now probably the most detailed analysis in Clitheroe and Bond. You've got a pretty solid base for saying that Banks and Goodfellow is the test. And I suppose it begs the question whether anyone really wants to take the matter any further in this or any other case. What difference does it make? Does it matter in any particular case? The main distinction between the two being where the burden of proof lies.
Yeah, I guess. Sorry. What I was going to add was, I guess, from a practitioner's point of view, that perhaps makes it ever less attractive to plead the Mental Capacity Act in the alternative.
Yes, I mean, I think actually the real importance of some of the burden of proof points actually comes in a lot earlier, because it's when you're making the will, and in particular the golden rule, that one should investigate these, that one should look at capacity where there is doubt, because if it's right that the burden of proof has been reversed. So it's now upon the person asserting lack of capacity, the person challenging the will, to approve a lack of capacity. That then it changes the evidential incentives at the time you're making the will. If you don't want your will challenged, don't go anywhere near a medical practitioner if there's some doubt, or if you know where the golden rule might apply. You've turned the golden rule on its head. So that is a major consideration. Now, until the courts, if they ever do, say definitively that the burden of proof is reversed, then that's not going to be a problem. But going into any case, I suppose that the difficulty you've got is, how am I actually going to get this argument in front of a judge, given the High Court authority on this?
Yeah.
Are we going to be able to set the goalposts at an early stage in the case so that we can fairly then run the evidence? I mean, you'd have to essentially run all the points and put all the matters to the experts and address both tests in the evidence, if the judge will allow you to do it, given the High Court authorities. So is it actually going to happen in practice, and is it worth it? Is it worth the costs and effort of running it? I don't know. But I mean, really, this should be a matter for the Law Commission for Parliament if they want to change the law.
Let's, if we may, turn to the question of delusion, something that always fascinates me in these sorts of cases, because of, you know, your starting point being cases that were decided in the Victorian era, and the medical evidence that and the medical knowledge that we had then and what we had now. So what our viewers and listeners might be interested in, Ed, is for you to tell us a little bit more about the test for delusions. What is a delusion, and what point do you have to reach before you can say that it's robbed you of the capacity to make a valid will?
Yes. I mean, there's been, as you say, there's a lot of very old case law on it. And the trouble with some of that case law was that at the time, insanity and delusions were kind of equated. Yeah. And so there's a real difficulty with placing too much reliance on it. And you'll see cases like Dew and Clark, which was 1826, going to sort of medical textbooks at the time to discuss it. So really, things have moved on just a little bit since then. So, and some of the modern authorities, there's a handful of them, don't really go into a huge amount of detail. So actually, Clitheroe and Bond, we did look at in quite some detail as to what the test is. And actually the psychiatric test, which was more or less agreed between the experts, is this: it's a fixed false belief of morbid origin, inconsistent with the patient's cultural or educational background. So you can break that down into a number of factors. It must be a false belief, obviously. But just because somebody believes something that's not true doesn't make it a delusion. We can have mistakes, simply harsh judgments. I mean, it's well established you can make a will through mean, capricious, or unreasonable motives. That's not a problem. So it's got to be of morbid origin. In other words, as a result of some sort of mental illness. Now, just pausing there, one of the things that the experts agreed on in this case was that actually you can have mental illnesses for which a delusion delusions are the only evidence, essentially, of a presumed disorder. So I suppose the more delusional, the more extreme the beliefs, and the greater the extent of the beliefs, you may be able to establish that it just goes beyond what's explicable on any other basis. And where the case actually really turned in this case was whether the belief was fixed, and that seemed to be where the debate, much the debate lay. Were these beliefs that are just beliefs that the gene had come up with, but could be reasoned out of, the point being that delusions don't yield to reason. And there was a huge debate about what the test is in that regard and how one goes about proving it, because there's an odd comment in some of the cases that it must be shown that the testator was incapable of being reasoned out of it, and whether that implied that one must actually have a challenge during the lifetime of the testator where somebody says, that's nonsense, whatever it is you're believing. Why do you believe that? Oh, well, I believe it anyway. Or, oh no, you're quite right, I'll stop believing. That doesn't happen. That's the reality. That doesn't happen in most cases because, of course, the in-person with any interest in challenging the belief may well not know anything about it. In this case, there'd been an estrangement. So Sue really wasn't in a position to challenge the majority of the beliefs that were held. There were one or two, but that's very much a matter of the facts of this case, and that hasn't yet been determined by the court. So we can't go into that too much detail. But there was this debate about whether there actually has to be a challenge, or whether you have to put yourself in the hypothetical situation of what would have happened if there'd been a challenge. And what, in fact, Mrs Justice Falk said very sensibly was, no, actually, look, we're not going to be prescriptive about the way in which we prove that the belief was fixed. One can look at all sorts of factors. Critically, whether this was a belief that was held in the face of any evidence, or indeed a belief that was formed completely in the absence of evidence. So in this case, for example, if a belief was held that the testator, given their state of knowledge, they must have known it to be false, how could they have formed that belief? Is that a delusion? That was part of the test. So one looks at all the circumstances. It's a holistic test. One looks at all the factors, what the evidence is. If there was a challenge, did it yield to the challenge? How strong was the challenge? How strong was the other evidence? Was it held in the face of evidence? How long was the belief held for? Why was it formed in the first place? It's a global assessment, and that must be, we say, the right decision, because why would one need to be prescriptive about the evidence, especially when, and this is the distinction between the psychiatric approach and the court's approach. The court has to look at this retrospectively when it's too late to do an analysis of what the testator may or may not have believed, fine during their lifetime, but once they're dead, you can't ask the question.
Yeah. I'm interested, just sort of deviating slightly from that. I know that below, it wasn't a subject to conversation or submissions before Mrs Justice Falk, but there seemed below that there was quite a potential close link between, on the one hand, saying that the testatrix was suffering from delusions, but on the other hand, saying her mind had been poisoned, that the delusions had been planted in her by John, I think, wasn't it? So the calumny, calumny test.
Yeah, I mean, below it was a kind of either or argument. So we said, look, she's got these false beliefs. There's only two explanations we say for those false beliefs. One is that it was a delusion, that it came from it has a morbid origin. The other, because we say these beliefs are false and couldn't come from anywhere else, is that they were put in her mind by someone else. In other words, what we said, John, and alleged fraudulent calumny, that the judge didn't find fraudulent calumny, he found for us on the delusions. It was a kind of either or situation, but that's why we ran it.
Yeah. Let's go back to delusions. What's the, crucially, how do you go about proving that the testator's delusions have caused a lack of testamentary capacity in terms of, I'm thinking from a very practical perspective now, when you're settling your pleadings, you're putting it all together. Can you give us some guidance about that?
Well, first of all, the burden of proof is relevant. It is for the person propounding the will to show, if there were delusions, that those delusions did not affect the making of the will. So if somebody had some very strange beliefs but were completely unconnected with the making of the will, that wouldn't be a problem. But as soon as you have delusional beliefs, in particular about the people who might have been cut out of the will, then you've got a real difficulty as the person propounding it, because you've got to show that it didn't affect the will in any way, and that may be a very difficult task. So that's the burden of proof. But I mean, in terms of establishing delusions, I mean, I think there are a couple of the sort of dividing lines between delusions and something else, whether it's just a harsh judgment and so on. That may be where one has to look quite carefully at the evidence. And I think in many of the cases where delusional arguments, where the argument has succeeded, that there were delusions, tend to be where there are specific beliefs. So rather than he's a bad sort, I don't like him very much, but what is the reason for that? I don't like it because he's stealing from me, because he wants to put me in a care home, because he's attacked me, he's been abusive. These are the sorts of specific factual assertions which in some of the cases are found to be demonstrably false. And of course, why would they have, the testator would know the truth. If they were in their right mind, they would know that wasn't true. And so that tends to be the sort of beliefs that's actually going to give you a pretty promising case. However, I mean, there are cases where it's just such a harsh judgment. I think Borton and Knight and Dew and Clark some of the Victorian cases may fall into this category, where the judgment was just so harsh and unreasonable that it sort of crossed the line. And it may be that that's actually that psychiatrists and lawyers might disagree about that one. But there's the suggestion in the case law that things just become at an extreme level, then you do cross the line. So I think in terms of value judgments, that's where I'd be looking for. How extreme is this? Yeah. But in terms of building a case, what I really want to look at specific beliefs, factual beliefs that we can say objectively are true or false.
I suppose that leads neatly on to the final area that we'll cover this morning, and that's what's the best approach to expert evidence in these sorts of cases. Obviously, I know, having read this decision, the judge has gone into a lot of detail. He had a lot of expert evidence, but there was quite a marked difference of approach, I think. Can you tell us
yes,
guidance on whose evidence the judge preferred and why?
Yes. There was so the two experts were Professor Jacobi for Sue and Dr. Series for John, and I think it became apparent during the difference between the experts wasn't perhaps as marked as it might have been, but they had a different approach to the evidence. And the thing that emerged from Dr. Series' evidence was that he felt very much constrained by the fact that there hadn't been a sort of a formal psychiatric assessment of Jean during her lifetime, and therefore was sort of nervous about sort of going as far as to say that she did have a disorder. Sorry. But I remember the master commenting that he thought that was a sort of applying a clinical standard, the certainty that you might expect to make a clinical decision. Whereas Professor Jacobi took a rather different approach and said, well, I'm an expert looking at this retrospectively. I'm not in a clinical setting. And in this task, he said, perfection is the enemy of the good. It's very, very rare, or at least certainly very unusual, that one would have an actual psychiatric assessment looking at testamentary capacity of somebody during their lifetime. He said, you work with what you've got, and you have to form a view on the balance of probabilities, taking into account all the evidence, which is not just the medical evidence. One of the advantages we had in Professor Jacobi's evidence was that he had read all the witness statements, and he was able to say, look, many of these issues are factual issues. I can't really comment on that. That's a matter for the court. But if court you find that these things are proved, then that would lead into my opinion. It would support my opinion or not, as the case may be. So he was able to give this holistic assessment. And I mean, really, he was talking the same language as the judge, if I can put it like that. He was speaking to the task that the judge had, the burden of proof, and the evidence that the judge was considering. And I think that's why ultimately he was preferred. I mean, there was this exchange in cross-examination with Dr. Series where, I mean, I put the burden of proof specifically to him. Could he be satisfied? Could he say that it's more likely than not that she did not have an affective disorder? And there's only one answer that will do to that, which is yes, which he didn't give. So, in fact, he didn't come up to proof. And that was something that both Master Founder and Mrs Justice Falk agreed with. So that was, again, not approaching it from the stance of the burden of proof and the task before the court, I think, is where possibly that evidence came unstuck. Okay, no, that's fascinating, Ed, thank you. Just finally, I think there is a bit of a postscript to your case. Is that something practitioners need to be concerned about? Yeah, so what's actually happened is on Delusions, much as the judge has made the findings as to what the law is, she's adjourned the factual consideration of that issue, so how that test interacts with the facts, in order that the parties can have an opportunity to try to settle the case. Yeah. So, I mean, that's very much a fact-based issue. So it's not going to decide any particular new law. There's likely to be either the parties will settle, there'll be another judgment. But it may be that if there is a judgment, that might be of some interest in seeing the practical application of the test. But I don't think in terms of sort of revolutionary points of law, that's going to carve any new ground. Sure, great. Yeah. Ed, it's been great talking to you this morning. I hope you've all enjoyed it. Coffee's gone cold, I expect, because you'll have been fascinated by Ed's insights into this very important case. Thanks very much, everyone. Thank you. Thank you very much. My pleasure.